Police team barged into Gurgaon, office of OYO, and 80 lakhs forcefully extorted from OYO management at the behest of the complainant. They have asked for some 51 crores, my lords, for the 3 properties, which includes what is there in this.
In fact, the 2 other similar cases, my lords, this has been going on. The petitioners have been doing this, have been trying to defraud hoteliers and hotel owners, my lords. In fact, the owners of the Federation of Hoteliers, my lords, have filed a case before the Supreme Court, in fact.
Against that?
Against the petitioners. If your lordships may kindly peruse the charge sheet, my lords, at page number 70, my lords. This is the case wherein it's clear prima facie case has been made out regarding the offences of 420 and 406. The investigating officer has clearly, in column 17 of the charge sheet, my lords, has said that there's been a discrepancy in the ledger book which is present at the hotel physically, my lords, versus the final report submitted to the complainant, my lords.
Correct.
The clear case of cheating is what they have indicated, my lords. In
Page 71.
Page 70, my lords.
70. All right. Yes.
They have highlighted the discrepancies, my lords. Thereafter, they have gone on to say that ಹೀಗೆ ಆರೋಪಿಗಳು ಪ್ರತಿ ತಿಂಗಳು ತಪ್ಪು ಮಾಹಿತಿಯನ್ನು ನೀಡಿ ಆಕ್ರಮ ಲಾಭವನ್ನು ಮಾಡಿಕೊಂಡು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಮೋಸವನ್ನು ಮಾಡುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಪ್ರಶ್ನಿಸಲಾಗಿದ್ದ ಸಾಕ್ಷಿ 1 ರವರು ಜಯನಗರವರ ಹೋಟೆಲ್ ಹೋಗಿ ಪ್ರಶ್ನೆಯನ್ನು ಮಾಡಲಾಗಿದ್ದಾರೆ. My lords, further, my lords, next sentence they have said that bouncers were kept by the petitioners, my lords. All of this indicates to the intent, my lords. There's been an intent to cheat the complainant, my lords, time and again, my lords.
Bouncers will cheat you?
Illa, my lords. I'm just trying to highlight the intention of the petitioner, my lords, so that we don't go. This was on a surprise visit by the complainant that we got a hold of this ledger book, my lords, and we were able to see the discrepancies, my lords. Subsequently, after that, my lords, they've kept bouncers and trying to restrict our entrance into the premises, my lords. And in the, my lords, when the charge sheet has clearly indicated prima facie evidence, my lords, we believe that intention is a matter of fact and is a question of fact, my lords, and it must be tried, my lords. There's also a judgment of your lordships.
You gave it in the morning.
Please, my lords. Yes. And there's another judgment of your lordships itself, my lords, wherein
both civil and crime.
Ila, my lords, wherein your lordships have said that in case of, even though a civil dispute regarding money recovery is pending, my lords, if cheating has been established, my lords, which has been established by the chart, the 6th line, my lords.
Yes.
It is the tried law that criminal law cannot be set into motion for recovery of money unless the offence of cheating or even criminal breach of trust is established. My lords, in this case, my lords, the investigating officer has held that there has been a case of cheating, my lords. There has been an intention to cheat the complainants, my lords. In fact, the 2 other similar cases, my lords, this has been going on. The petitioners have been doing this, have been trying to defraud hoteliers and hotel owners, my lords. In fact, the owners of the Federation of Hoteliers, my lords, have filed a case before the Supreme Court, in fact, my lords.
Against that?
Against the petitioners.
All right. You have completed, Maten. Sandesh, sir.
My lords, ಇವತ್ತು ಸಿನಾಪ್ಸಿಸ್ ನಾವು ಕೊಟ್ಟಿದ್ರಲ್ಲಿ so much has been told about what the charge sheet contains. The investigating officer, my lords, who filed the charge sheet, if my lords would notice serial number 21, 22, 23, my lords. Now what he does is
in the charge sheet.
Alla, nam synopsis alli. In synopsis.
Ivat koಟ್ಟಿದ್ರಲ್ಲ.
ಹೌದು.
All right. Yes.
ಅದರಲ್ಲಿ 21 ತಾವು ನೋಡಿದ್ರೆ they issue a notice under 41A, my lords. 3/4/2023. Then, my lords, 10/4/2023, second notice which was issued under 41A. Now, please notice, my lords, 26 alli, 10/4/2023, the police team, they go to Gurgaon.
One sec, JY. Yes.
My lords, I'm sorry. This notice koduvaga, they gave us 7 days to reply. 10th, they go to Gurgaon. Please notice 26, what they do there. Police team barge into Gurgaon, office of OYO, and 80 lakhs forcefully extorted from OYO management at the behest of the complainant. Now, we gave a complaint, my lords, to the Commissioner of Police, my lords. There was an inquiry that was to happen. My lords, I understand the investigating officer, my lords, he passed away. When he was facing the heat about what he did in Gurgaon, my lords, he passed away. And this is the charge sheet, column 17, which is being read. And column 17 is only to the effect of saying discrepancy in accounts. Now, what is their case, my lords? Their whole case is certain benchmark which they should have got, they have not got. What is the claim filed by them? They have asked for some 51 crores, my lords, for the 3 properties, which includes what is there in this. My lords, the judgments which were relied on, whether it is Preeti Shroff or my lords' judgments, distinctly where there's criminal intent. But my lords, where a matter is arising out of an agreement, there's dispute in terms of who owes whom what. We have made the claim, they have done the counter claim. In our claim, my lords, we have asked for few crores from them. They say we owe them 51 crores, which is subject matter now before the arbitrator. Now, in case of this nature, my lords, whether we see any ingredients of offense being made out or whether it is predominantly civil in nature, my lords, and the judgments which I have given is till 2025. And in fact, my lords, finally, my lord's judgment in Malavika, Periyaswamy, but my lord's judgment,
I think latest.
25th June 2025.
ಮೊನ್ನೆ
My lords,
promise
yes, my lords, where they say even just merely because you make your complaint voluminous or charge sheet voluminous, that is not what has to be
Content.
taken into consideration. The content is important. And that's why, my lords, on the aspect of clever drafting, my lords, we have put in the other 3 judgments.
Muhammad Ali.
Yeah, Muhammad Ali and then my lord Salib, then Wajib. Even Wajib is also one more case of clever drafting. 3. Here, my lords, even
950 and 951. 950 is Muhammad Ali. 2023 SEC online is 951 is Muhammad Wajib.
and my lord, similar complaints which were done under OYO, the coordinate bench which has quashed it is also part of that compilation, my lords. So anyhow we look at it, my lords, on 3 factors also. Predominantly a civil dispute, a cloak of criminality.
We'll see.
Ingredient is absolutely lacking, and this is done as an only vengeful act of arm twisting us to come to a settlement.
Well,
Those two just to clarify, those 2 cases are on a separate footing, my lords.
yeah,
because there
this
was-
is Hemant Avardu.
Please, my lords, and no investigation was conducted in that, no charge sheet was filed, my lords.
It was at the threshold, it was quashed.
At the stage of FIR, that those 2 petitions were quashed, I mean allowed.
That's the difference. Yes, Jagdish.
In fact, my lord.
Hello. Sorry.
Hemant Avardu FIR,
Alla, Hemant avre FIR alla, the out mugisli, my lord, both the
Aye,
judgment.
yes.
The fact, my lord, that they've undershown the bookings, undershown the accommodation in the hotel.
So intention to cheat.
Itself, intention to cheat is manifestly exists in the complaint. Just because the civil suit has been filed, my lord, this cannot be taken away.
Civil suit ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ, arbitration.
Even arbitration, my lord.
Civil suit is pending.
As the hearing progressed, the court examined allegations of cheating and financial discrepancies linked to hotel bookings and payments. The petitioner argued that the dispute was purely civil, a matter of money recovery, and claimed criminal law was being wrongly used to pressure them. But the prosecution relied on the investigating officer's report, pointing to mismatches in hotel ledger records and alleging a clear intention to deceive complainant, while also claiming similar complaints existed against the petitioners. The court noted that the investigation report contained substantive findings, not mere allegations, and questioned why it should interfere at this stage. Ultimately, the bench observed that if the petitioner believes the charges are unjustified, the proper remedy would be to seek discharge before the trial court rather than invoke extraordinary jurisdiction.